Hello, YouTube. I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from the YouTube user. The price is wrong. The price is wrong. And the price is wrong asks us, really appreciate your content. Appreciate you saying that. Would love to hear your input regarding a specific situation. Outside of a class action lawsuit, is there any alternative benefit and or strategy to employ from having knowledge of additional employees, former coworkers, pursuing litigation against the same employer? Before, during, and after the EEOC process. Thank you, and I hope you're enjoying your summer. Thank you. The price is wrong. I guess it is summer, and I am enjoying it. Although I am not yet in Portugal, which is bumming me out. I'm trying to film this big backlog of videos so I can get my butt to Portugal and enjoy myself. Also considering a bit of a summer. I don't know. Kind of sick of the hair in the heat. I think I might just kind of want to cut it all off. Summer ideas. All right, let's grapple with your question here. So you have a lawsuit against your employer. It's an individual lawsuit. You're not in a class action, and you know of other coworkers, past, present coworkers, who also have claims. Immediately, if the claims are ongoing, collaborate. Contact their attorneys, have your attorney contact their attorneys, be like, hey, we'll help you if we can, you help us if you can. We can share evidence, we can share discovery, we can share strategy, we can share testimony, right? Like your testimony could help them, their testimony could help you. You could show a pattern of practice in terms of like a discrimination or sexual harassment or retaliation pattern in the job site. There's tremendous value there. Also, don't sleep on past cases. Listen, first off, that person could potentially still testify for you. If the case is settled, they might be subject to an NDA, but you can still subpoena them, beat that confidentiality agreement generally. But also, like their litigation, if it's on a public docket, there's a lot you can learn. You can pour over their motions, the motion to dismiss they might have faced, and their opposition papers. You can pour over the summary judgment motion that was made and the opposition papers and the exhibits. Can't stress enough, the exhibits. So you can see the arguments that were made. You can see the counter arguments that were made. You can see the documentation that was used to substantiate and build a foundational element for those arguments. And you can use those for your case. There's no reason you can't. Now, you might want to ask for them in discovery again, so you have a clear chain of custody in your case. It might be a little easier, but one, you know to ask for them, and two, if you can't get them in discovery, at least you know they exist and you have them in hand, and you can say, hey, yeah, this was put forward as discovery in this case, and this is an exhibit, and it can be a tremendous value. So listen, can't stress enough, you are on the right path here. The price is wrong. In fact, the plan is right. You would reach out to ongoing litigants for collaboration. You would reach out to past litigants, people have already run their case, and say, hey, I might need you to testify. Would you be willing? Or you might just subpoena them if you have to, a little less friendly, not the friendliest thing to do to somebody you want to testify for you, but sometimes we must do what we must. But also, like, these cases, these current cases, these past cases, can be treasure troves of evidence and treasure troves of strategy, like seeing what's already happened. What has the employer done? What have successful litigants done? What have unsuccessful litigants done? What path did they go down? Right? That has value too. Like, if I knew an associate was like sleeping on the bad cases against an employer, that the cases that went nowhere, they just lost, like, deep concerns. Like, why would you not be curious about the cases that lost in summary judgment? What arguments were made there? What did the employer do to win that case in summary judgment? That seems shocking. How is that case differentiated from ours? And if the answer is, oh, there's actually no similarities between our case and that case, that's fine then. But we want to know that. We want to know that, right? Because if there are similarities, we need to be looking. How did this case lose in summary judgment? Why did this case not proceed to trial? Why Why did it do well at trial when it did proceed to trial? Why was the damages verdict? It won, but why was the verdict lower than we wanted it to be? We don't want this verdict for our client. We want a verdict 3 to 8 times that, you know? Why did this case win, but not win what we hope to win in our case? Like what is different? What are we looking at? What did they do? What mistakes, what shortfalls, what failures of aggression, what failures of detail-oriented behavior? What happened, right? And you can mine these cases. You can mine these public dockets. Stuff that's confidential, EEOC stuff that might not be available, you can still file that FOIA request, right? But it might take a little while, but it might be worth your time. But arbitrations might not be available. They might be confidential. And listen, that's unfortunate, but if you know they happened, you can still subpoena that person. They might not be able to speak to you. They might be subject to a confidentiality agreement. But if you subpoena them, almost certainly that confidentiality agreement will be out the window because you can't beat the court. So the plan is good. You are correct. And I applaud you. This is good thinking. And you bring up something really valuable for people on the channel to see. So I thank you. If this was helpful, like, subscribe, comment down below, share our channel so it can grow. And that is the only way that people see our channel. If you share it, if you like it, if you comment, that is how the algorithm sees us. That's how other people just like you see us. And it does help us to help more people just like you, sincerely. So consider. Thank you. Take care, everybody.